Here, we come here, it is nothing.
Do you have any info if someone else is going to join us?
I will join in 10 minutes.
Yeah.
I will join in 10 minutes. I'm on my way.
You're on your way. Okay, great. Someone keeps silencing this. Then I cannot hear you properly. Alexander, no information about him? No. Anastasia is going to join us later. She has something for the first hour of the lecture today, but she will join us as soon as she can. And Martin, you don't know who he wants to come. He should be. He should be present here in person. Great. Okay. We can wait for a couple of more minutes. It's just 2 minutes past 6. Maybe we can use this time as an opportunity to discuss any technical dilemmas that you may have regarding the registration of the exams, verifying the semester, anything that bothers you, because I got several inquiries from some of you by email, so I get the idea that some issues are maybe not clear enough. So feel free to ask me anything.
We have some problems with students.
Okay.
But we have
Maria, secretary. The Department for Postgraduate Studies. Yeah.
And yeah, for me, I did specify.
Okay.
Well, when you have time view of the date of the exam, we don't have the.
You got the email asking you to register for the exams.
We did.
You did. So the next step will be that Maria contacts professors once we know which exams are going to be held during the January examination term. She contacts the professors who will conduct the exam, and then they give her the date for the exam. And then Maria informs you about it. We usually give, for example, only one date, because there are not many of you for the entire examination term. This does not necessarily mean that, for example, if you are out of the country or you get sick or for any other extraordinary circumstances, you're not able to attend the exam. Usually, for example, I will be happy to do that. I can then give you an alternative date. So I will have the official date on the list with your names for the exam, but I can keep it until the end of the examination term, and then you can come take the exam at some other date. What also I would like to ask you is whether you prefer, for example, for international and EU law and gender equality, I don't know how many of you wish to take this exam in January examination term, because you do, whether it would be more convenient for you to take this exam at the beginning of the examination term or towards the end, which is usually the case. So I can, in line with what we agree upon, I can, for example, schedule the exam for the last or one of the last days of the examination term, so that you now have an idea when this exam will be held.
Yeah, but I have another question.
Okay, that's why I asked you. Yeah.
Time of the exam, during the hours or
Yeah. Well, what we just to approach the microphone so that the others can hear me who are online as well. What I usually do, not just me, but others as well, I link this day with my exams bachelor studies. For example, I start at 10 a.m. with bachelor studies, then continue with master studies around 1 p.m., 2 p.m. If this is not convenient for you, maybe we can now agree on some afternoon term, whatever you prefer. If you are working,
yeah, I mean, it's better if
it's possible.
Time, yeah, if that is an option, because otherwise.
Sorry, Alex. No, Martin. Yeah, Alexander. We were expecting Alexander to join us. Martin, welcome.
Yeah, sorry to be late.
No, we are not. So we haven't started yet. We're discussing some technical issues regarding the registration for the exams. That might be of interest for you as well, because you should also do that, even though you are Erasmus student. Okay.
They told us to remember which
exams you want to take. Okay. Where were we? Yeah. So I can give you one day in the afternoon hours for exam, if you like. Which time is best for you?
Just to be clear, when we were talking about written exam, due date for the written exam,
Well, a couple of days earlier, because I need time to read it.
And do we need to on the day of the exam?
Yes, you do, because you do. Even if you opt for the written form of the exam, you write an essay. Now we are discussing another course.
Okay.
Not this one, because I will be the one examining them, this other course. So I need you to send me the paper, the essay, 2, 3, 4 days earlier, prior to the exam date. Then I will get back to you with my comments, general impressions, and suggest a mark. Great. Having into consideration your participation, involvement, activity, assignments, I will consult, as I mentioned earlier, with other professors who worked with you, and then suggest a grade. You may be satisfied with it and just take it, meaning that you will come to the official date of the exam with your student booklet and with this small piece of paper you remember from bachelor studies, the report. No, you were not our student here. So there is this small piece of paper called report on the exam. You can, I think, take it. I don't think, or buy it. Just take it.
There will be a bunch.
Yeah, there will be next to the copy office or the bookstores downstairs. I have no idea. Well, I don't know. Yeah, but don't blame me. It's not up to me. So you have to have this small piece of paper where you enter the title of the exam, you sign it, you enter the number of your student booklet, and the rest should be written by the examiner. the grade and the date and the signature of the examiner.
And they collect it?
And I keep that. I keep that. And I submit that to the office for postgraduate studies together with the official list. So that's the thing you need, and you bring your student booklet, and I just write down your grade. In case, but if that hasn't happened yet, you are not satisfied with your grade, you can opt for taking the exam in the oral form in the next examination term. So I cannot.
Because me personally, I'm not gonna opt for the January.
Okay.
But for the February, or if something eventually happens, should we just tell you prior that we are gonna go in February, or?
No, I will get the information who takes the exam from the list that I get. So I will see your names, and I generally know who takes the exam in a written form, who opted for the oral exam, and I will know whether to expect you and whether to expect the essay a couple of days prior. If I do not receive the essay and you opted for the written exam, I know that you will not take the exam this examination term, but the next one. Everything clear now? One other thing. Alexander asked me this, he wrote an email to me this during the day today, so I got also the idea that you're not familiar with that. You need our signatures in your student booklets for every course that you take. You also have student booklets. Index. The index, yeah. So when the course is coming to an end, for example, during the last lectures or near the end, towards the end of the course, you should bring with you your student booklet to the classes and ask the professor to just sign it. It's a formality. Everyone will get a signature. If you do not get it during classes, you can always write to the professor an email asking, when can I find you at the faculty in your office? I just need your signatures, so it won't be any problem. In any way, you need signatures from any of the professors who delivered lectures. For example, for the human rights and gender equality, you can take either mine or Professor Kristic or Professor Tanasija Marinkovic. So it really doesn't matter. You only need, so you can even, since some of us, we teach more courses, you can get from the same person several signatures for different courses. This is also an option. And you need it for this, again, formality of verifying the semester, or I don't know whether this is a proper translation. Something you need.
And we do that after.
Yeah. You will get this information from Maria. So Maria will inform you when you should start thinking about it and taking care. Yeah, when the semester is over. Okay.
Well, the signatures, but we don't know when to verify. I don't know when. Yeah.
When these two courses end. Yeah. On the 6th of February is the end of this semester. That's when, but even after that, if you miss some signature, no problem. Just write an email, ask when can I find you at the faculty, I need your signature, and then come and get the signature. So it's really a formality, doesn't mean anything. We know who was present all the time. We write down these things. Okay, so anything else? Erasmus students, everything fine?
I think so, yeah.
Martin, I was surprised today. I was thinking about you.
Professor,
Actually, yeah, Saiful.
I
Just a
want
second,
to
please.
write an essay for this course. You can
Sorry, I didn't hear you.
write essay for this course.
Essay, okay.
For this course, that course you read. I don't.
Yeah.
Focusing on not oral question, focusing on writing essay. Send me that.
You are referring to the international and EU law and gender equality.
Yes.
So as I explained in my email, Saiful, you should think about one or two or several potential topics that are of interest to you and that relate to what we discussed during this course. And then write me an email, okay?
Okay. Thank you.
That's how it works.
That Raju, ma'am.
Martin, coming back to you. We were discussing your case the whole day because somehow it happened that I have your learning agreement, but some older version of it. Back when you opted for courses in Master in European Integration, I did not know that you opted for all the courses within LOGEM.
Yes.
Yeah, I don't have this final version of your learning agreement, and I started, registering you for courses within Master in European Integration because I'm in charge of that master program. But now everything is clear. I know that you changed your courses and that you decided to take all the courses from this program, which is of course fine. But there was some miscommunication between different departments that I could.
But now you have my right.
Yeah. The important thing is that I do not expect you to follow, some courses at the Master in European Integration, and that because of Pekic and Maria who are administering this master program, they have all the courses that you will be attending. Okay, so everything is fine, but this is something that happened. Ksenia, welcome. Hello. I'm so happy that this evening there are so many of you present here in the classroom. It will be really a change because last time we had only three girls here, and now it's Saiful and Shamarke online. Alexander, we're still missing, but we'll see. I hope he'll join us. You know from the working schedule what we are supposed to discuss this evening. And as I announced the last time, at the end of our discussion of human trafficking, the topic for today will not be any brighter or easier. We will continue discussing some really disturbing issues. So we are supposed to talk about the prohibition of torture and other forms of ill treatment. I'm not familiar with how, with your knowledge in this area. We all, as usual, have some idea about what ill treatment is, what torture is. You will see what other forms of ill treatment that are not considered as severe as torture are also there. But one thing is what we perceive as such acts. The other thing is how such concepts are defined legally through legal instruments. And as we will see this evening, it actually depends on the legal system that we are talking about. For example, torture and other forms of ill treatment will be defined in one way by the UN Convention Against Torture, but not necessarily in the same way by the International Covenant on Civil and Political Rights or the European Convention on Human Rights. So the definitions may vary, and this is what we are going to discuss this evening. Of course, the focus along the way will be on gender aspects of torture and ill treatment, because there are some forms of torture, ill treatment that disproportionately affect women. There are some forms of ill treatment that produce more severe or different consequences when victims are women. The way to, handle the trauma which was born out of such acts might be different if the victim is a man or a woman, etc., etc. So essentially, this is what we are going to discuss this evening. Regarding terminology, I will be using the term ill treatment as the most widest concept, encompassing different forms of ill treatment. Among them, as you will see, are torture as the most severe one. Then we have inhuman and cruel treatment, which are there in some international instruments, although the distinction is not always visible or clear. And then we have degrading treatment. So you can see that within ill treatment, acts of ill treatment, a person can be submitted or can be exposed to torture as the most severe one. Then a less severe form of ill treatment would be inhuman and cruel treatment. And the least severe one would be degrading treatment. Maybe even through the words that are used, you can guess what kind of treatment could be qualified as torture, inhuman, or degrading. But as the presentation continues, I will explain, based on certain legal instruments and jurisprudence of relevant bodies, how these concepts are understood. Okay? But for the beginning, when I say ill treatment, I think about all of them, irrelevant of the degree of severity or the nature of the act. But sometimes, it is important whether, for example, the European Court of Human Rights or the Committee Against Torture or the Human Rights Committee, whether it qualifies some situation as a torture or as a degrading treatment. It counts. It really matters, especially to whom? To the victim. Not only to the victim at the first place, but also to the rest of the community and the perpetrators. It does send a signal how, dehumanizing was a specific act towards the victim. But let's take it slowly. Okay, so all in all, what we are going to discuss today is, first of all, how both torture but also other forms of ill treatment are defined legally. This is important because this is human rights law and gender equality course. But also what we're going to check whether these power dynamics based on gender, whether they in some way or another influence how we perceive torture and how actually they influence the qualification of an act as a torture or inhuman or degrading treatment. Especially having in mind that originally, historically, when this concept of torture started to evolve, with which situations do you associate torture with? In which situations torture is usually committed? Una, prison, of course, meaning that it is usually committed by whom? Police officers, so the state, because police officers, their acts are attributed to the state. So this was one element which has to be considered. Another one is that victims were usually men, victims of torture. So men were usually tortured in prisons in a different context. For example, what you have as cases before international bodies are those counter-terrorism actions, actually suspected terrorists being in prison, in custody, and then they were exposed to different forms of torture. Why? In order to get some information from them. Although, getting information out of a person can be only one among different purposes that relevant actors use in order to commit torture. But the fact is that at the beginning, torture disproportionately affected men, not women. Why else? Because, back then, when these international legal instruments started to develop, there was this strong idea of a division between what is public and what is private. So what happened in home, in the privacy of someone's flat, that was not something that could be qualified as torture because there was no state involvement. However, owing to the jurisprudence of relevant international bodies, you will see later on that even such acts to which women are disproportionately exposed, domestic violence, gender-based violence, sexual violence, rape, marital rape, whatever you want, whichever example we take, this can also amount to torture, even though there is not a direct involvement of state or state officials. This is something that I mentioned. So there's division between public and private, and who commits torture, state actors or also non-state actors who can commit torture, and what would be then the link with the state. If the non-state actor commits torture or other form of ill treatment towards a victim, what would be, Una, the connection with the state?
Well, the obligations that the state has, for example, independent investigation, what happened, or to stop the treatment, react to complaints, and
to offer protection to the victim, to have the legal framework in place. For example, domestic violence, it's still not considered a criminal act in many states, which might come as a surprise, but that's the fact. So that could also be something to be reproached to the state because it failed to take those steps because they are considered prevention. Otherwise, it's legal. It's not contrary to the law. Okay, so if we put this into the gender context, gender relevant context, gender can be relevant and important when it comes to the form of torture and other forms of ill treatment. The circumstances in which it occurs can also be gender related. The consequences, as I mentioned, will be different whether the victim is a woman or a man. And also, in what way the response of relevant authorities should be designed and implemented can be influenced by the fact that the victim is a woman. So, in other words, there is a strong gender dimension of ill treatment, both torture and other forms. If we take a look at all those different forms of ill treatment, regardless whether it is torture, whether it is inhuman, cruel treatment, degrading treatment, they all have something in common. That is why they are considered ill treatment as a group of acts that share something in common. So what do they share in common? First of all, absence of respect for human dignity. Even if you have a degrading act, again, you are attacking someone's dignity. Even though, as I said, the severeness, the seriousness of the suffering is the least, but still, it influences a person's dignity. Method of intimidation, humiliation, breaking of resistance. So regardless of whether the particular act is torture, inhuman, cruel, degrading treatment, they all try to do this. This is the purpose, trying to break a person in order to get something from it, or simply, show that you have control and power over that person. what is else relevant is that both attacks on physical and mental integrity of a person count. So even psychological violence over a person can be considered torture. So both the attack towards physical integrity and mental integrity of a person can amount to ill treatment. This is something that we discussed. Usually and originally, such acts were widespread in prisons, in custody, in other closed type institutions, even psychiatric institutions. So for example, centers for asylum seekers, if they are closed types, or even if they are semi-open types. So such situations, such places, in them, persons that are at higher risks of becoming victims of ill treatment. But as I mentioned, the standards have been developing lately. So even outside such contexts, a person can be exposed to tortures or ill treatment in its home or in relations with other persons, but outside the official custody by the state. In any way, what they all have in common is this abuse of power by the torturer or the person executing ill treatment. Now, the most difficult part, to see how ill treatment, different forms of ill treatment, are perceived and regulated by relevant international instruments. And as always, I will make a distinction between the universal level and the regional level. Can you give me some international universal treaties that are relevant for the prohibition of torture? Which ones count? Universal. The European is a regional. UN Charter does not contain a catalog of human rights. It has an overall provision saying that this protection of human rights is one of the aims of the UN, but it does not regulate torture.
Convention for forbidden for torture.
Convention against torture, that's right. This is a UN treaty, a universal one, and a specialized treaty. So this is the treaty which is dedicated to these acts. It forbids and it regulates these acts and, of course, duties of states. What else? Do we have the prohibition of torture within general human rights treaties at universal level? Which one is the most important? Parker? No. But, international human rights treaties. Which one is most important at the universal, that's again regional level? The pact, international, actually covenant. Covenant, that's the English word. International covenant on civil and political rights. And there is also another one at the universal level with which it all started, the Universal Charter on Human Rights. Maybe you had that charter in mind. Or the UN Charter? Which one?
Up with the UN.
The UN Charter. Then you had the Universal Charter. Okay, so Una confused me. So the Universal Charter on Human Rights, of course. So these are the universal instruments. Regional, you mentioned European Convention on Human Rights. Anything else?
I don't know if that is regional, but the practice from the tribunal, from Rwanda and
the International Criminal Tribunals. No, that's again the UN level because they are ad hoc bodies to the Security Council of the UN. No. The European Convention But then you also have in other regions, the American Convention, the African Charter. We won't go into details regarding them. We'll stick to the European Convention, but there are some other regional treaties. Before I explain all of that, what you need to understand is that we are not discussing this evening just any kind of human right or any prohibition. This is a very specific one for a number of reasons. First of all, the prohibition of torture is jus cogens. What does it mean? It is imperative. It means that it obliges all states, whether they are parties to relevant treaties or not, that there are no exceptions. So besides being an imperative, jus cogens rule of international law and international human rights law, this is also an absolute prohibition, meaning that you cannot, expose someone to torture and then explain, I did that because of this, this, and that. No, there are no excuses. You cannot provide any exceptions to such a prohibition. This is an absolute prohibition, which means what? Even in times of emergency, even if the life of the nation is endangered, you have some extraordinary circumstances. Even, terrorists threatening to throw a nuclear bomb, which would result in the extinction of the entire population, still there are no options. I mean, this is the very extreme example, but that's the essence, there are no exceptions. And last but not least, this prohibition is a rule of customary law, meaning what I mentioned earlier. Even for states who are not parties to relevant international treaties, for example, the United States of America, they are not party to the most important human rights treaties. But this is the customary rule of international law. It obliges them as well. The other side of the coin is whether they will respect it. But anyway, they are bound by it, regardless of the fact whether they are a party to the ICCPR or the UN Convention Against Torture, etc., etc. So just throughout this class, have this in mind. So this is not just any rule. This is among the most important rules that international law and international human rights law have. Imperative, absolute, customary. With one remark, I mentioned that ill treatment refers to various acts: torture, inhuman or cruel, and degrading treatment. Are all of them imperative, absolute, customary? They should, but it actually depends on the legal system that we are talking about. For example, the Human Rights Committee within the ICCPR, Covenant on Civil and Political Rights, considers the entirety of Article 7, which prohibits torture, cruel, inhuman, degrading treaty, as absolute, as customary, as imperative. But the UN Convention Against Torture does not do that. It considers only torture as absolute, imperative, not the other courts. With the European Court of Human Rights, things are not that clear, because the court tends to not, qualify a particular situation as either torture, inhuman, or degrading treatment. It simply says that this situation falls within the ambit of Article 3, full stop. So we are not really aware of the position of the European Court of Human Rights. But nevertheless, with torture, there are no dilemmas. Torture is prohibited as an imperative norm, as an absolute norm, and as a customary rule of international law. This is something that we discussed. The only thing that we did not mention is the Convention on the Rights of the Child. Don't forget that it so prohibits torture, not in Article 19, but 37. So I will correct this. But other documents we mentioned. It all started with the Universal Declaration of Human Rights. You can see Article 5, providing that no one shall be subjected to torture or to cruel, inhuman, or degrading treatment or punishment. Just as a way of reminding you, what is the difference between Universal Charter and the rest? Hello, Anastasia. You were quicker than I thought you would be. You said the first hour. Welcome. So do you remember what's the difference between the Universal Declaration of Human Rights and the other international conventions on human rights? What's the difference? Is this a treaty? No, that's not a treaty. So it is a resolution of the UN General Assembly. Additionally, it does not have a monitoring mechanism. There is no body which oversees whether states respect the provisions of the Declaration on Universal Declaration of Human Rights. But anyway, it does contain the prohibition of torture. More important one is the ICCPR, International Covenant on Civil and Political Rights. There you have Article 7, which says no one shall be subjected to torture or to cruel, inhuman, or degrading treatment or punishment. In particular, no one shall be subjected without his free consent to medical or scientific experimentation. So what is the added value of the covenant as opposed to the Universal Declaration of Human Rights?
Experimentation.
This, medical or scientific experimentation, which enabled the covenant, the Committee on Human Rights to, for example, some cases of forced sterilization. Case with other international human rights treaties. So the very formulation of the provision does not make a distinction whether the victim is
he's free.
That's right. That's right. But no one. No, you are right. This is something that is also critiqued for the UN Convention Against Torture. You will see it also uses the word him. But you see, this is very concise and brief provision. How do we know in which way it should be interpreted? Who can we go to? Whose work we should consult in order to have an idea how these words, how these concepts that are included in this provision should be interpreted, generally and with gender-related issues in particular. The Human Rights Committee. So, Martin and Myla, Anastasia as well, you were not within these other courses where we discussed this, and I'm not familiar what's your knowledge relating these international mechanisms, but this treaty, the International Covenant on Civil and Political Rights, it has a monitoring body. This is the Human Rights Committee. It is an expert body that has ways to oversee whether the contracting parties, whether states, respect their commitments. How they can do that? Well, individuals can submit complaints to the committee, and then committee can say whether the state violated the covenant or not. States have to submit reports to the Human Rights Committee, and then the committee comes back to the state with so-called general conclusions and say, you did this right, you're doing this well, but this practice or this legislation of yours, it's not in line with your international commitments. And the third option are so-called general recommendations or general comments, depending on the treaty body, where the committee, based on its practice, actually interprets this. So when it comes to the Human Rights Committee, of relevance for Article 7 is the General Comment number 20, which was adopted in 1992, so a rather old document, but a very useful one, and the only one that we have when it comes to interpretation of Article 7, which prohibits torture and other forms of ill treatment. So what did we get from the committee as an explanation of this brief provision? First of all, that it protects both physical and mental integrity. So there is no doubt regarding that. Ill treatment will not be just physical violence over a person, but also psychological trauma that a person can have by being threatened, not necessarily, harmed physically. This is the first important thing. Then we got the information that whether inflicted by people acting in their official capacity, outside their official capacity, or in private capacity, this will amount to torture or other forms of ill treatment. Why is this important? Because of this initial perception of torture as something done by the state and done by state officers, public officials. Within the ICCPR system, you can see that this is irrelevant. Torture or any of the other acts prohibited by Article 7 of the ICCPR can also be committed by persons acting in their private capacity, anyone. Allows of no limitation. So there is no justification or extenuating circumstances that can be invoked to excuse a violation of Article 7 for any reasons. Meaning what? There are no exceptions. Article 7 is absolute. The entirety of Article 7, so not just torture, but also inhuman, cruel, degrading treatment. The committee said, yes, there is no definition of torture, of cruel treatment, of inhuman treatment, degrading treatment. We will not do that. We will not provide a list of acts. For example, being beaten severely, or, being exposed to some terrible forms of treatment. The committee did not want to go into that. Why do you think was that the case?
Because there are too many.
There are too many.
And there will always be new.
And there will always be something which is not on the list. So the list may be indicative, but it is not exhaustive. However, the committee did not want to go into that. It said the distinction depends on the nature, purpose, and severity of the treatment applied. And what the committee usually does, it does not enter into specific qualification. It just says sometimes when it is so severe, it does qualify the act as torture. But in other cases, it simply says it is contrary to Article 7. It does not go into detail whether the particular act is torture or inhuman, cruel, or degrading treatment. And last but not least, the safeguard said that Article 7 safeguards for the special protection of particularly vulnerable persons. Now, have in mind this is 1992, when the committee adopted this general comment. and it refers to detainees as particularly vulnerable persons because of the obvious reasons we discussed. It all started with that idea that persons in who are detained, who are deprived of liberty, are at risk of becoming victims of torture. But then, just 8 years later, in 2000, the Human Rights Committee gave another general comment, number 28, where it interpreted Article 7 in line with Article 3 of the ICCPR. And Article 3 is the classic gender equality provision, which says that all the rights and freedoms provided in the ICCPR are to be enjoyed by women and men on an equal basis. And besides that, also positive measures in all areas should be taken in order to achieve the effective and equal empowerment of women. So this general comment actually put this Article 7 in the context of its specificities related to gender. So what did we get from the HRC, from Human Rights Committee, through this general comment? The committee said all states, when they report, they should inform us about national laws and practice with regard to domestic and other types of violence against women, including rape. Suggesting what? That these acts may be torture or other forms of ill treatment prohibited by Article 7. A very important thing, domestic violence, rape. So not those acts to which men were usually exposed to. Whether the state party gives access to safe abortion to women who have become pregnant as a result of rape is also something that the committee asks states to provide as information. Measures to prevent forced abortion or forced sterilization, female genital mutilation, meaning that actually the committee considers all these practices of gender-based violence as being able to become torture. If, of course, if the level, the degree of severity and suffering, which is inherent to torture and ill treatment, is achieved. Measures of protection, including legal remedies for women whose rights under Article 7 have been violated. Why is this important? Especially, actually, regardless of whether these ill treatment acts happen at home or in custody, in prison, so by private actors, non-state actors, or by the state. Women might have a problem receiving adequate reaction from the competent authorities that they go to in order to get protection. So this is why the committee stressed the relevance of this access to justice and access to measures of protection and remedies, of course. Whether men and women are separated in prisons and whether women are guarded only by female guards, that girls and generally children should be separated from adults in prison, and pregnant women who are deprived of their liberty should receive humane treatment during the birth and while caring for their newborn children. So you can see that through this general comment number 28, the committee interpreted Article 7 in a gender-sensitive manner based on its previous practice. So these are actually the standards of the Human Rights Committee. Just briefly, I mentioned the Convention on the Rights of the Child. Article 19 prohibits all forms of physical and mental violence over children, but Article 37 prohibits explicitly torture and other cruel and inhuman or degrading treatment or punishment, which is the body overseeing the implementation of the Convention on the Rights of the Child. Also, the Committee on the Rights of the Child. Again, you can see this provision is very brief, is very concise. But thanks to the work of the Committee on the Rights of the Child, we got again some general comments. We don't have time to go into details regarding them, but you have them on the slide. The most important one from the perspective of gender effects of torture when it comes to girls and harmful practices over girls is the last one. Joint General Recommendation number 31 of the CEDAW Committee and the Committee on the Rights of the Child. It's 2019, and it deals with harmful practices that disproportionately affect girls. So female genital mutilation, child and forced marriage, crimes in the name of the so-called honor. So relevant international standards of these two committees jointly given are provided in this general recommendation, okay? And finally, the UN Convention Against Torture. The most important instrument, why? Because it is a specialized instrument. It deals only with torture. You know, the ICCPR, the Human Rights Committee, it has a range of other rights and prohibitions to deal with. CAT, the Committee Against Torture, only deals with torture, and it supervises the implementation of the UN Convention Against Torture. You can see by the number of states, it has 175 state parties. So it's really widely accepted among the members of the international community. Etc. When, and this is important, when such pain or suffering is inflicted by or at the instigation or with the consent or acquiescence of a public official or other person acting in an official capacity. How do you understand this?
It includes domestic violence.
Yeah.
Anybody?
At least at first sight. At least at first sight. And if we interpret this, if we give this provision a very narrow interpretation. So it does suggest that for a person to be exposed to torture, the state official needs to do that. But take a look at this. With the consent or acquiescence of a public official. What is acquiescence? Pristanak. Approval. Any ideas how we can interpret this?
We can interpret it as if the state allows for domestic violence to happen, then
That's right.
it's positive obligation to actually prevent.
That's right.
So it can be seen.
It can. And as you will see, we got some hints from the Committee Against Torture that this provision can be interpreted in such a way, but it took a very long time to get to that point. For years, and at the beginning, the Committee Against Torture took this provision strictly by the state official, meaning you need to have a state official involved for an act of torture to be committed. So this is maybe a better overview of the elements that are contained in this provision that I had on the previous slide. So what are the elements of torture? Any act. So the convention does not go into an exhaustive list of acts. So any act can count. That there is severe suffering, pain. So this is the second element. Then there needs to be intentional infliction. So there needs to be intent to submit someone to torture, to such act. For impermissible purposes being listed in the very provision, taking out information, confession, punishment, etc. And last but not least, and very important, state involvement in one way or another, either as a direct involvement or an indirect involvement, meaning there were some measures that the state could have done to either prevent that or to protect the victim, and it did nothing. Article 16 of the CAT defines the other forms of ill treatment. So Article 1 defines torture, and you had the elements of torture on the previous slide. Now Article 16 defines other forms of ill treatment. Each state party shall undertake to prevent in any territory under its jurisdiction other acts of cruel, inhuman, or degrading treatment or punishment which do not amount to torture as defined in Article 1, when such acts are committed by or at the instigation of or with the consent or acquiescence of a public official or other person acting in an official capacity. How do you interpret this provision? And does it tell us something more about the difference between cruel, inhuman, degrading treatment? No. It just tells us that there are some problematic ill treatment acts that will not amount to torture, but still you need to have what? The involvement of the state. So under both scenarios, whether it is torture or other forms of ill treatment, state involvement needs to be there according to the Convention Against Torture. The Committee Against Torture, just as is the case with the Human Rights Committee, does not go into details and little qualification whether a particular situation is inhuman, cruel, degrading treatment. It does sometimes differentiate between torture and other forms of ill treatment if the situation is very severe, the suffering that the victim was exposed to, but it does not differentiate strictly between these other concepts.
And we don't have definition for inhuman.
No. Within the Committee Against Torture and Convention Against Torture, not. But you will see the European Convention on Human Rights has that. So what I want you to understand, how we understand and what these different acts and concepts, legal concepts mean, it actually depends on the legal system that we are applying. One situation is with the ICCPR, the other is with CAT, the third one is with the European Convention on Human Rights. Some issues are very similar, but they do differ. Okay? Una, fine. You're looking at me like, you're confused? No? Okay. Just briefly, so these are the positive obligations that states have with regard to torture when it comes to the Convention Against Torture. They have a duty to prevent it. They have a duty to investigate and prosecute the executors of torture and other forms of ill treatment, and they have the duty to protect the victims. You remember the last time when we talked about human trafficking, the 3 Ps. Prevention, maybe that would be the easiest way to remember that. Prevention, protection, prosecution. It's the same here. It's more or less the case with all the international human rights treaties regarding the prohibition of such acts. When it comes to gender sensitiveness and gender responsiveness of the Convention Against Torture, there are no gender sensitive provisions, as you could see. Again, no one shall be exposed to. And alternatively, wording is used person as a gender neutral, blind language, and him. But have in mind, this is convention dating back to 1984 when the text was dropped. So gender issues were not on the agenda then. I think this is something you know. So the Committee Against Torture is the body, the treaty body, expert body that oversees the implementation of the Convention Against Torture. And there is an option for individuals to bring complaints again before the committee. But also, the committee can check what's happening in a particular country through the reports that the country is sending to it. And it can also use this inquiry procedure if there are systematic problems when it comes to ill treatment in a particular country, then the committee can, deal in more detail with that specific party of the Convention Against Torture.
And they're also doing visits, right?
No. There is another body at the regional level called CPT. Maybe you are referring to that. A Committee on the Prevention of Torture. But this is a regional body established by the European Convention Against Torture. And the only thing they can do is pay visits to countries. They do not receive individual complaints. They only do visits. But the Committee Against Torture will not usually do that. They will maybe do that during inquiry procedures with countries that have systematic problems with torture. As you are used to. So this very brief, you remember the brief, actually not that brief, provision of Article 1 of the CAT and Article 16 of CAT, they are interpreted by the Committee Against Torture. Again, the Committee Against Torture can adopt general comments that provide relevant interpretation of the provisions of the Convention Against Torture. And the only one that we have so far, and that is relevant for gender issues, is general comment number 2 on the implementation of Article 2 of the Convention, which provides the duty to prevent torture. And actually, we got some really important signals and standards from the committee. First of all, it said that it remarked that state reports frequently lack specific and sufficient information on the implementation of the convention with respect to women, meaning that the committee actually expects states to pay attention to women and how they are implementing treaty obligations with regard to this particular group. What else the committee said is that gender is a key factor because it can be decisive in how a person actually experiences a particular act and what consequences it will have to deal with, he or she will have to deal with regard to gender. The committee also stressed the relevance of the intersectionality approach, meaning what? Gender is a key factor, but which other characteristics count?
Race,
Of course. Migration status, etc., etc. So the committee is also aware of this. It also says the context in which females are at risk include deprivation of liberty, medical treatment, particularly involving reproductive decisions, and violence by private actors in communities and homes. Mm-hmm. Why is this so important? No difference between the private-public dichotomy. And last one, in red, suggesting that this is very important. Where state authorities fail to exercise due diligence to prevent, investigate, prosecute, and punish non-state actors, its officials should be considered as authors, complicit, or otherwise responsible under the convention for consenting to or acquiescing in such impermissible acts. The state official does not have to be the one to commit torture. But if the state does nothing to prevent it, to protect the victim, to prosecute the perpetrator, then that last element, which was very problematic, is resolved. It's no problem anymore. This is the committee who said that. Okay? So with this general comment, we got very gender-sensitive interpretation of an otherwise gender-neutral or even not so gender-neutral provision. But the most important thing is that this division between home and the public sphere is now erased. Even domestic violence or rape or sexual violence, marital rape, can be considered as torture.
I think also it's important that today the medical treatment is part of involved with reproductive decisions, because we have just abortion till now, and we had pregnant, but when they're delivering of
That's right.
liberty, and I think the obstetric violence
That's right.
in the world, not just
That's
here,
right.
it's a topic where you can challenge and ill treat.
Of course, definitely. Other harmful practices that disproportionately affect women, they are not explicitly mentioned here, but it goes without saying that they may also amount to torture. Before I go to the case study, and then after the case study, I suggest we make a break before we go to the regional instruments. I have one last question. Which is the most important treaty when it comes to protection of women's rights? CEDAW. Why don't I have CEDAW on the slides? And it is a universal instrument.
Equality. The general comment or recommendation in the previous slide. It wasn't.
Together with the Committee on the Rights of the Child, yes, but why don't I have a provision of the CEDAW Convention prohibiting torture? It doesn't have. No, that's right. It doesn't have a particular provision. Well, I don't know, but this is not a particular problem, because owing to the jurisprudence of the CEDAW committee, and some of its general comments, we got to confirmation that gender-based violence may amount to torture as well. So the fact that there is no particular provision does not have to mean that torture of women is allowed. No, but there are some other provisions that can be interpreted in the following, in the relevant manner. Okay, now the first case study. Any volunteer to read it? It's a bit longer, but this was a very, very difficult case. This is a real case before the UN Committee Against Torture. Any volunteer? Or do you prefer to read it in silence? Okay, Ksenia, yeah.
He was conducting life parole as an officer of the Burundian National Army. During his shift, he visited the home of his friend, who was not at home, only his wife and 9-year-old daughter. He said that he wished to leave, and he asked the mother to allow her daughter to accompany him. She refused. She then returned to the kitchen. A few minutes later, she called her daughter to request assistance, but found that her daughter was no longer home. She tried to find her, but without success. The girl returns home tomorrow morning. Several days later, the girl explained that he raped her. When she cried and wailed, he showed her his firearm and threatened to kill her unless she immediately stopped. The next day, he gave the child 500 Burundian francs, approximately 0.30 US dollars. He wanted her never to speak to anyone about what had happened, threatening her and also her mother if she revealed their secret. The girl at first told her mother not to, as she was afraid she would die or that something awful would happen to her family. When the victim's father broached the subject with D, he proposed an out-of-court settlement whereby he would pay for the victim to remain quiet. The mother firmly rejected the arrangement, whereas her husband was in favor of coming to terms. The husband eventually left the family home, so the mother was alone in pursuing the matter before the domestic courts. She took the girl to the center, which provides victims of sexual violence with medical, psychological, and legal assistance. The victim received comprehensive care there. Medical examination certified severe intimate injuries. 8 months after the rape, the case was dismissed, owing to the absence of elements of an offense. The sole basis cited for dismissing the case was the relatively long period of 10 days before the victim reported the incident, and the captain's claim and availability to the investigators.
A real case. So it's not a made-up case. It's a real case. Okay, so the facts are clear to you. Okay, I have a number of questions to you. First of all, how would you qualify her situation? Is it torture or is it inhuman, cruel, degrading treatment? So Article 1 or Article 16? Because I remind you, this is the case before the UN Committee Against Torture, which applies the Convention Against Torture. So the rules of the Convention apply. Would you say that this is torture or other forms of ill treatment?
And suffering involvement of the state.
Mm-hmm. You need other elements. I will go back with this slide. So we have the act, any act. Severe pain or suffering. Which factors would you stress as the most relevant from the facts of the case to claim that this element of severe pain and suffering was met? She's a minor. She's a 9-year-old girl. Okay, what else?
And that she was crying. I think that can be suffering.
Mm-hmm.
And the medical exam confirmed that there were, even after days and days after that there were physical consequences.
This is not putting the facts of the case simply. I could not put everything, but after this happened, she completely closed. Did not want to speak to anyone. Did not want to go to school. So her psychological situation was very, very problematic and bad. So this is also something to take into account. She was threatened, which also caused mental suffering. So she, of course, physically suffered because she was the victim of rape. But the fact that he threatened her, he threatened even, she was fearing for her life, for the life of her mother, because he is not just any person. He is a member of the army.
Big they left me to their house.
That's right. He was a friend of her father. That's right. Intentional infliction. Is this element met?
Well, there is an intent to rape. And in our, I don't know how they would look at intent. I don't know if the intent to torture or to cause ill treatment or some, or is that important? Or
No, this person does not make a distinction between torture and human degrading treatment. I mean, no one expects him to do, but raping someone, it cannot be unintentional.
But I think in our city, if you look at our criminal act, for example, it would be very important for distinction for the criminal offense. Is the attempt to rape or to torture or to kill or to it's important to this
No.
that
In this,
we can
no, it's not the idea. It's not the idea here. Even you have it below. This is not, to assess this subjective element. This element of intentional infliction is also there in order to prove the severity, but objective severity of the trauma and of suffering that the victim was exposed to. Impermissible purposes. There cannot be permissible purposes to commit rape. And state involvement. This is very peculiar case. So he was an officer of the Burundian army. So even this element was met, even though, he did not do that in his official capacity. Well, did he, Martin?
Well, he was on duty during the time. So I would say that it's still state involvement. When he used his gun, probably provided by the state for his duty.
That's right.
As his,
even though he took her to his home, he did it in his home. So maybe he was not on duty while he was doing that, but still he threatened her with his gun. And he has this gun only because he is the member of the Burundian army. Otherwise, he would not have this gun. So you can see all the elements are met. And the Committee Against Torture qualified this as torture. So it said we don't need to go into Article 16, whether this is inhuman, degrading treatment, punishment. This is torture, which is a good thing. It sends a message that rape can amount to torture. The other side of the story is state's duties. Once we qualify a situation as amounting to either Article 1 or Article 16, what is the next thing that the committee does, which is also important? See what the state did wrong. Because the first issue is whether this is torture or inhuman, degrading treatment. But this is not the end. This complaint was brought against Burundi before the Committee Against Torture. So was there something that Burundi should have done to act in line with its international duties and failed to do that in order for its responsibility to be established? So what do you think?
Of course, they failed to.
Let's go one step at a time. So remember 3 positive obligations, 3 groups of obligations. PPP. First P, prevention. What would you have to check in that regard? What would be relevant? You don't have that in the fact of the case, but ask me anything that you think would be of importance to say whether Burundi violated the duty to prevent torture in this particular case.
They have law. Great part of this. I don't know if this goes in line, but also having psychological examination of people who enter state services, such as violence.
Okay. It should be important. The committee did not go into that. There were plenty of other issues to consider. But the first thing that you mentioned, yes, legislative framework. So whether there are relevant laws that prohibit such behavior, and whether you have some kind of a system, institutional system, to be put into function once such acts happen. And, there was something like that in Burundi. The laws were fine. There was an ombudsperson. There was commissioner for human rights, etc.
Were they applying for the rape or for the torture when they were?
I don't
Or is that
remember, but what would be relevant is whether the criminal acts were treated as a minor offense or more relevant. I can find. I have here the entire.
Yeah,
but I don't
the
remember.
fact that it is a minor presented as a higher risk.
But is that relevant for the first set of duties, duty to prevent, or for the last one, duty to investigate and to prosecute? Huh? You should think about that in this third set.
But also, if you don't have the possibility to recognize the minor as
That's right. That's right. That's right. Here, in this case, it did provide, Burundian law did provide that victims who are less than 12 years old, regarding them, a special treatment applies. So again, when it comes to legislative framework, everything was okay. The committee found that Burundi did not violate the duty to prevent. Let's go to the second one, to protect. What would be of relevance there? Does it matter, legal, of course, does it matter, let's stick to medical, psychological, does it matter whether she had an opportunity to go to some public services to get relevant counseling and protection, or if the only way was to go to an NGO who provides such kind of counseling, which was the case here. So the committee said she did receive proper treatment, but what was relevant is that state had nothing to do with that. State could not hide behind NGOs doing something that the state should be doing. The state should also have relevant services in place which are functioning to offer protection and support to such victims. This was not the case.
But also, if those services existed, they were if we are talking about the ideal system, they will be intertwined with the prosecution.
Excellent, excellent. Multi-sectoral cooperation, something which is in such cases very, very relevant. Whether there is communication among police, prosecutor, doctors, medical facilities, even NGOs who are providing protection. So this is something that was, again, missing in this particular case. And the third, so the court said that they violated this duty. And the third one, legal proceedings, prosecution. They simply dismissed the case. That, he was behaving good. His temper was calm while we interviewed him, It is. The judge was also changed. So one person was conducting the investigation. The mother approached the prosecutor's office and the police a number of times, asking how is the investigation going, whether there are any results, etc. They told her, we are doing everything we can, don't worry. And then they simply dismissed it. So there were important failures in this regard as well. Okay, I think it's time for the break. Agree? 10 minutes, 15 minutes. 15? 10. Okay.
Ja, nema više. Ja imam
Dobro, ajde napravit ćemo se. Ne mogu da vam kažem, sad ne pitate. Ne mora neki dan da bude malo. Svaki dan. To nije mnogo.
A ja idem u Rusiju mesec dana, ja mislim februaru će biti plus 10, plus 15.
Ja sam čula da će biti opet novi, najsnijega igrica.
Ja ne mogu.
Na području, da. Ja se još nije tako je.
Kako da tamo nego da zemlja?
Do maja. Pa nekad imamo sneg u maju.
Ja, da ne.
Kad sam bila u novembru, na kraju Da, ja, došla u Europe plus student.
Da.
Ja, ok,
Da, neki bi tako šok. Nije bilo toliko šokova. Nije bilo, ali ja sam došla i ja sam bilo
Ajde.
Andiamo.
Ovo je ipak slabo malo. Koji sam je pokirao.
Uzdržavajući.
Mogu kod da, što je
Ja sam se malo razla nikom. Tako je dobro.
tako, mi se čini bolje, no. Iskreno.
Budeš da staviti ne, zašto da ne.
Ne, ti si mene nalupa na ovo. Da, ja sam otišla u nebu na 5 kesa. Znate, pa sam tu bila hladnjena sam kući. I sad svaki dan pojim koji ja ne kažem. To sam vrde otrovnici. Oprema kalorije.
Nema problema.
Znate, da sam pojim da ne kažem.
Mislim da nema bilo.
Ali molite, non-fry, vegetarian, no preservative, no glutamat, šta god bilo. Ali to uvijek toliko malo. Onda
Šta je što te uzelo?
da ti to pridaš na?
Evo, evo se mi.
Kako mi to? Da, preko mogu dobro.
I pitala sam se stavila, meni ja sam znala.
Da.
Pa na ovo telo. To je kako da se stavila. Kako je važno meni. Kovice nemaju kalorije. To je tako lažno. Znači,
Ja da je to lažno.
zato je to. To se ne uvijek. Ono je reći, ja da ću meni čekati. Samo tu je to.
Pa nije postavljeno.
Nema. Ali možemo.
Ja i kupe.
Skala
Tako da, nula kalorija moja.
Što sam uvijekala neke reći, svađala se s tom djevojkom i kaže, nema sojno mleko kalorija, a mi kaže, kako nema sojno mleko, barem 10 ima, nema.
Meni se rekao da nisi ti biti športal, kao ne bi da znate što ti je jedan problem? Kaže ne bi. Nisam vodama.
Zato nemaš. Kako meni?
Kao, ali ne ti za mene je
Zato je biti dobar. Još ne je ovo pojela. Bravo. Znaš što znam da me gledam to?
Nije dobro.
Imaju neki koji kao ali ima preko, kao kako. Gde? Kao stiropor. Nisam sigurna da je manjki. Kao četiri.
Na platku samo tako da tako me nosim. Bukvalno nisam mogla dođe do njega, nije bila šansa. Drago mi je
Rekla je, bit će financijer, dobit će tenis i presudu i mi da ispravno napišemo da uređujemo.
Ja sam imala prva replika. Ovo je
Ja sam čuva.
Ja sam šta se ti zaključila? Brada, da sam pitala. Može budete taj.
Milina da bude
Ja to već da pomijenila.
What do you intend to take in the January examination term?
We applied for the first three that we already listened.
Yeah.
Two.
Yeah.
Okay.
Because 2 of us, we want oral exam.
Yes, we will have.
International. And yeah, I thought that was the only one, but now I found out that they also, we're gonna go in January. So for her, it's also better if it will be after the working time.
Or
no
somewhere.
problem. No problem. No problem. So what, after 5 or even 6?
After 5.
5
Okay.
years, yeah, 6.
6. Fine. No problem. I will
And
have that
that's
on
what they.
mind.
That's something.
I didn't understand you.
Later term of the exam, so by the end.
Oh, by the end, that goes without saying. That goes without saying. Okay. You do not plan any business trips in that period? No. Fine.
Sorry for not being able to.
No worries. It's fine. Ready to continue? Tired? No. Martin is tired, although he was not working the entire day. You know, they were at work all, and then they came to take classes.
7.
You woke up at 7. Yes. What? Jogging? Doing some sports or whatever. Boxing class. Well, you can see better that than go to work. Yeah. Okay. Just to go through the regional instruments, and I prepared again some case studies based on the jurisprudence of the European Court of Human Rights for the end. What was initially the plan, and you could see that in the working schedule, we were also supposed to cover this evening the gender aspects of the non-refoulement principle. But I won't do this tonight because it was very important for me to go thoroughly through these issues and for you to understand different concepts and rules that apply. And then next time, since we are talking anyway about the gender aspects of international refugee law, and non-refoulement principle is one of the cornerstones of international refugee law, this will be the perfect timing to discuss that as well. Okay, so I did not forget about that. Don't worry, just I postponed it for the next session. At the regional level, what we have is Article 3 of the European Convention on Human Rights. Again, a very brief provision: no one shall be subjected to torture or to inhuman or degrading treatment or punishment. You see that what is missing here in the definition or in the formulation is which concept? Cruel treatment. You had cruel treatment both in the CAT and the ICCPR. It's missing here, but generally cruel and inhuman, it's very difficult to make the distinction. So inhuman covers both.
We don't have states.
You did not have state involvement either in the ICCPR, provision 7. It was again, very similar to this one. So only the CAT has that in its formulation of Article 1 and 16. But we'll see whether the court and how it interprets that. Una mentioned the CPT, so you can see this is the regional body. I already mentioned that, and I will skip it, just so you know that there is such an option as well. Article 3, a very brief provision, again gives us no information. What is torture? What is inhuman? What is degrading treatment and punishment? But who do we turn to? The court. The court interpreted those concepts through its case law. And it also defined the duties of states. When it comes to the definition of torture, the European Court of Human Rights relies on the definition of Article 1 from the Convention Against Torture, the one that has state involvement as an element. But through its interpretation, it did a very, not restrictive, but extensive interpretation of such wording, in the sense that we discussed earlier. State involvement, acquiescence, consent means state did not act with due diligence. There were some measures at state's disposal to prevent it, to protect the victim, to prosecute it. It failed to do that. This is meant as the fulfilled element of state involvement in the context of Article 1. So the European Court of Human Rights does refer to Article 1 CAT for the definition of torture, but it interprets it very extensively. Okay. As you can see, these are different acts in the European Convention, Article 3. Torture, inhuman treatment, inhuman punishment, degrading treatment, degrading punishment. It is very easy to differentiate between punishment and treatment. You can do that on your own. There is no problem. But still, what is not very clear is what is torture, what is inhuman, what is degrading treatment. We got the answers from the court through its case law. And here it is. How the court works, how it reasons. When it gets a case which contains allegations of violation of Article 3, first it will look into the facts of the case and assess whether the situation to which the person was exposed amounts to violations of Article 3, actually whether the acts and the suffering attained the minimum level of severity which is required for Article 3 to be applied. To make it more simple, it will assess whether the ill treatment, the acts to which a person was exposed were severe enough. Mm-hmm. But this is a preliminary assessment, just to see whether it fits into Article 3. Mm-hmm. So whether it attained, this is the formulation that the court uses, whether it attained the minimum level of severity. It does not say what is the minimum level of severity, but it depends on all the circumstances of the case. What will the court take into account? Do you have any ideas? Without looking at the slide, because the answers are there. But just think, what would be of relevance for the court to see when a person comes to it and says, this happened to me, I was exposed to such treatment. What would the court, which factors would it take into account?
Oh, the treatment was
If there's some evidence
conducted.
Proof.
injuries.
Okay, but not even regardless of the proofs. It will deal with proof later. But based on something that the person claims happened to it, which factors? That's right. The age of the person, its mental and physical health, gender, the duration of the act, whether it was one-time event or something that happened for, I don't know, several months, several years. So all this will actually count. All the relevant factors the court will take into account. So both objective and subjective. Because, a particular act may be considered ill treatment regarding person A, but not taking into account the circumstances of person B. Mm-hmm. So everything matters, both the nature of the act, the severity of the act, but also the personal circumstances and vulnerability of the victim. So everything counts. And taking an overall assessment of all these factors, the court will say, yes, this is serious enough to be qualified as potentially contrary to Article 3. And then later it will see whether it actually was the case. What do we have in Article 3? You remember torture, inhuman, degrading treatment or punishment. From the court, we got the explanation of those acts. The court says what is relevant is the intensity of the caused suffering. Torture is treatment that caused very serious and cruel psychological or mental suffering with an intentional infliction. Very serious and cruel. Inhuman treatment is causing intense physical or mental suffering. Can you tell the difference between very serious and cruel physical and mental suffering and intense physical and mental suffering? Yeah, it can. It can. And the third one, degrading treatment that humiliates a person. That is maybe the easiest to understand. But what is more difficult is to make a distinction between torture and inhuman treatment. But here you have examples from the case law of the court. You see the example for torture. The applicant was subjected to physical violence, including with PVC pipes, as well as psychological abuse, such as threat of rape and sexual violence, while held incommunicado at the basement of Chechen police headquarters on account of his homosexuality.
It has a lot of different elements.
Yeah.
Not just one.
And all of them taken together suggest that the suffering the person was exposed to was very serious and cruel. Take a look at the example for inhuman treatment. The applicant suffered uncertainty and apprehension over a prolonged and continuing period due to the disappearance of his relative. This is not degrading treatment, and this is not torture, but this is inhuman treatment. The person suffered because it did not know about anything about the whereabouts of its dear person, his or her dear person. So I gave you these examples just to have some overall idea of what should be considered as torture, inhuman or degrading treatment. But it's very difficult to tell in a particular case.
Especially if we talk about some gender-related, for example, rape, it's not
Especially. That's right. That's right. For that reason, what the court usually does, even though it has these standards, so it did, in a way, make a distinction, define between these concepts. For the first time, the only one who did that is the European Court of Human Rights. We did not have this either by the Human Rights Committee or the Committee Against Torture. But still, it rarely qualifies a situation as torture, inhuman, degrading treatment. It simply says the situation, the facts of the case, the acts to which the person was exposed were such that they qualify as acts against Article 3. Full stop. Doesn't enter into whether it was torture, whether it was inhuman, whether it was degrading. Sometimes it does. Sometimes it does, but not always. Something that we discussed for a number of times. The difference between negative and positive obligations. This is the approach of the European Court as well. So every provision of the European Convention, including the prohibition of ill treatment, contains both negative duties for state parties, meaning that state officials cannot commit torture over a person, but also positive duties, meaning that even if another private person commits an act which is qualified as a treatment, the state has positive duties. Which ones? To prevent, to protect, to prosecute. And then, you have also the duty not to return a person. This is also an element of Article 3. This is something that we will be discussing next time. But have in mind that, the state does not have to torture a person on its territory. If the state returns a person to the territory of a state where he or she will be exposed to torture, it's the same as if it was committing torture itself. But as I said, this is something for the next time. Gender perspective of the prohibition of ill treatment. There are situations in which women are definitely exposed to an enhanced risk of ill treatment when they are held in custody, prison, deprived of liberty, when they are confronted with law enforcement officers, not necessarily in custody, not necessarily but in contact with law enforcement on protests, students, female students, in the garage of the government of the Republic of Serbia. Women victims of domestic violence, very often. Women victims of gender-based violence. When we say gender-based violence, meaning everything, female genital mutilation, other forms of honor crimes, forced sterilization, anything that can count as gender-based violence, human trafficking, so whatever can be qualified as gender-based violence. Women living in societies that have discriminatory laws, practices, and attitudes towards women as factors which encourage active gendered forms of torture, and also women deported to their countries of origin. Gendered forms of ill treatment, the first two are that classic situation where the state officials commit torture or ill treatment. But the last two are and will be of interest for us for the end of this class. So domestic violence and violence against women that are committed by private persons. So let's see what is the jurisprudence of the European Court of Human Rights in these particular cases. First, domestic violence as ill treatment. I have this here, another case. Anyone who's here now? Or Ksenia? Ksenia. Una would like to read.
I began living with my partner B in 2011. Onwards, she experienced repeated physical and verbal abuse, including severe assaults and
Strangulation.
Although medical professionals advised her to report the violence, no effective protective measures were taken. On August 10, 2014, during a violent quarrel, they allegedly assaulted Ms. Nicola and pushed her towards the open balcony of their 15-floor apartment. Fearing that she would be killed, she used the kitchen knife to defend herself and escape. She was arrested, charged with previous bodily harm, and detained overnight. Medical examinations confirmed a concussion and multiple injuries consistent with assault. Ms. Nicola saw accountability to a private prosecution for minor bodily harm. The court discontinued the case and referred to the police, considering that the facts prosecuted are more serious, publicly prosecutable offense. The police, nevertheless, refused to initiate criminal proceedings, finding that the death threats were not sufficiently real and that Ms. Nicola had no objective reason to fear for her life.
Classical case of domestic violence. So the facts are clear, you remember them. Okay, I have questions. Can the acts to which she was subjected be qualified as ill treatment? Yes, we all agree. All agree on that. Do you think that the acts to which she was subjected to attain the minimum level of severity? So this is the first step. You remember, the court assesses whether, according to the facts of the case, the situation to which she was exposed attains the minimum level of severity required by Article 3. Since we answered positively to the first question, it goes without saying that we agree regarding the other one as well. Which factors should be taken into account for assessing the minimum level of severity? Now, it was obvious, but what would you stress? What do you think the court took into account as relevant factors to assess it as minimum level of severity? Martin raised his hand.
I would say the duration, that it's for multiple years, and also that it got reported years ago already, and the doctors probably also wrote it down. So there's physical proof of assaults.
Okay. Great. Which type of ill treatment? Can you tell? Is this torture? Is this inhuman treatment? Is this degrading treatment? Or which one would you exclude for sure, and which would you be maybe thinking?
Maybe degrading treatment can be excluded because, I mean, it is degrading, but
It is.
not
It is not just degrading. That's right. That's right. And if you would have to opt for torture or inhuman treatment, having in mind the difference, you remember very serious, severe form of suffering. And
Can go with torture because he was fearing from her life for going down with the walker. So the possibility for
just imagine hanging from the 15th floor of the building. I mean, it's not just a slap, even though that is also can be ill treatment.
Maybe we can see that for the description, but even the fact that she was her and then she opted for to fight back, we didn't see, he put her and then okay, we will have to help her to come out and then continue fight. No, he was letting her be in that state. So I think the good element for coach.
Okay, great. Which positive obligations do the authorities have under Article 3? I'm sure that you all know the answer to this question because I repeated it so many times. Prevent, protect, and prosecute. Okay, so do you think, and what would you expect from the Russian authorities? This was, again, a Russian case. Sorry, Anastasia, it's simply, for no particular reasons, but these were landmark cases in this area. But generally, what would you think? How can a state discharge of its positive obligation to prevent and make sure that it will not be held responsible for violation of Article 3 in that respect?
Well, the thing that we know is the last obligation to prosecute.
Okay, but let's stick to the duty to prevent. So what do you expect from Russia to have in its legislative framework? Prohibition of domestic violence. I don't know whether anything changed. So this is a rather old case. 2013, 14, something like that. But back then, there was no legislation in Russia prohibiting domestic violence.
No.
Still, there is none. Yeah. Russia is not the party to the Istanbul Convention on Violence Against Women and Domestic Violence. If it were the party to that convention, it would have to have within its national legislation prohibition of such act and relevant protection to victims. For example, here in Serbia, we have a special law on the protection of the victims of domestic violence.
About it now, because a lot of people think that it will be so difficult to prove it, and someone can use it. For example, classical
Anyway, here in this case, the court said you did not fulfill your positive duty to prevent because you do not have an appropriate legal framework to answer to this commitment. What do you think about the second positive obligation, to protect? What were Russian authorities supposed to do in this case?
The fact that they just advised her to go to the police, but that institution didn't go by itself.
Yeah. And also when she entered the medical institution with obvious concussion, there should be a connection with the system there in order to help her.
To provide support, they cannot make her press charges. Even the Istanbul Convention has this as a principle. You should respect the will of the victim. You cannot condition providing support to the victim by requiring her to press charges. But you should do everything you can to explain to the victim what are the options, what are the possibilities. Yeah.
In Serbia, it goes like
In Serbia, there is a duty to not to press charges, but to report. To report. And this is something that Grevio, Grevio, the treaty body that oversees the implementation of the Istanbul Convention, something that they, in their report regarding Serbia, said should be reconsidered, because it is not in line with the Istanbul Convention. They do not say that this is not necessarily wrong. I mean, it is with the best intentions that this solution was included in the law. But still, what Grevio insists upon is that there should be autonomy on the part of the victim to decide what to do. But what the state needs to do is to inform. They have a duty to inform the victim of all the options that it has, of the available remedies, the available support services, who the victim should go to, having in mind her particular situation, whether she needs psychological counseling or she needs immediate protection because her life is threatened. In this case, this is the problem with domestic violence, because there is a cycle of violence. The victim is exposed to domestic violence, and then maybe for some time nothing would happen. But then what usually happens is that violence comes back, and when it comes back, it is even more severe. It is more fearful. And this is something that state authorities should have in mind. And this is something also that the European Court of Human Rights insists upon, and Grevio. So these are now considered international standards in this regard. When it comes to the third positive duty, to prosecute, they failed completely, because she was supposed to press charges herself, and she did that for the minor offense, not the offense that would be in line with actually what happened to her. And the police did not recognize death threats as sufficiently severe. And this is something that the European Court of Human Rights said was wrong. Even threats can count as ill treatment, because again, it all depends, of course, on the circumstances of the case, but death threats can also cause anguish, stress, fear that can amount to psychological ill treatment. Here we also have physical violence, but even threats can be psychological violence. Just before we go to the next case, one important element. In this case, the victim, in its application to the European Court of Human Rights, asked the court to qualify its situation as torture. It said, what happened to me is so serious that it should be qualified as torture. So not just any act contrary to Article 3, because you remember these can be very different things. She said, what happened to me is torture. However, the court said there is no need to go into that. We do understand what you want to achieve, that in that way you also want to send the message to the Russian authorities that they, in a way, are fine with this situation of impunity when it comes to domestic violence acts. But we do not want to go into this. Whether this was the right thing to do or not is another issue. I'm curious to know what you think. Do you think that the court should have done that and qualified the situation as torture?
But they used this article.
No, the court said it's violation of Article 3. But she said the message would be stronger for the victims, for the entire system, which is obviously not functioning properly and has flaws, if the court qualifies it as torture.
But did the court say, so we don't want to get into that, or no, this is not torture?
We do not want to get into that.
I think if you make a distinction, then there is a distinction, and in the practice of the court defined those distinctions, then
Why not? Yeah. Well, in my personal opinion, I think that we will get to that point eventually. But like what we discussed last time, even the court has to take it gradually and slowly. This was a big thing because the court, domestic violence cases considered to be contrary to Article 3. Mm-hmm. And it did, in this case, also stress the gender aspect of the acts to which she was exposed. So this was already not enough, but quite something. But I'm sure that with the further development of the court's case law, this will eventually happen, especially, because the European Court of Human Rights is very much, in such cases, under the influence of Grevio and of the Istanbul Convention. More and more in its practice, it relies on the findings and standards of Grevio. In this case also, because Russia was, as you remember, not party to the Istanbul Convention, the court also found not only the violation of Article 3, but also violation of Article 14 of the European Convention on Human Rights in conjunction with Article 3. Article 14, prohibition of discrimination. So the court said the continued failure to adopt legislation to combat domestic violence and the absence of any form of protection orders clearly demonstrates that the Russian authorities were reluctant to acknowledge the seriousness and extent of the problem of domestic violence in Russia and its discriminatory effect on women. By tolerating for many years the climate which was conducive to domestic violence, the Russian authorities have failed to create conditions for substantive gender equality. So this was also a huge thing achieved through this judgment. So again, the court takes it one step at a time, and it will further develop its standards, I'm sure. The next case study. JJ survived multiple rapes by her father. He was imprisoned. Extremely traumatized, suicidal, and self-harming, JJ changed her name, appearance, and domicile. While on leave, her abuser threatened to kill her through relatives because he held her responsible for his imprisonment. JJ repeatedly asked for police protection. None was provided. No investigation ensued. Officers were dismissive. JJ reported reported police misconduct. They persisted not investigating the threats. She was a young woman of Roma origin. Again, what would you say? Does this amount to the minimum level of severity required by Article 3? Yeah. Any idea how to qualify it? Is it torture? Is it inhuman, degrading treatment?
Torture.
But we will never know because the court again decided not to go into those aspects. It simply said this is contrary to Article 3. And if you go through the 3 sets of positive obligations, this is the case against Croatia. Do you think that Croatia violated the first, the second, the third, or all of them, or some of them?
I don't know about the first, but
You cannot know about the first because you don't have facts here. No, the court said everything was fine in Croatian laws. So it is a party to the Istanbul Convention. It implemented those duties into its national legal system. There are relevant provisions. There are relevant provisions even regarding these protective orders, which are very important in domestic violence cases. So everything was generally fine regarding that. The second set of positive obligations to provide protection.
Yeah, they were there. Police protection.
But also the fact that he was able to track her even after the imprisonment and after happened, I think this is
How should have they reacted to be in line with their European Convention on Human Rights commitments? What would be the perfect scenario? What do you think? How Croatia should have reacted the first time this girl went to them and said he's out to prison, or even before that, should they have informed her that he is leaving prison? Of course. What else? They should have summoned him and gave him again the restraining order, protection order, restraining order, and warned him that he was not to meet her. The poor girl, she called these SOS numbers for victims of domestic violence. It was an official number established by the state. And you know what they told her? They cannot do anything until he shows up at her doorstep.
Much not a severe thing that I know. Had a lot of issues.
That's right.
Recently, everyone says until he does something, we can do it. I mean, what?
Totally contrary to states' duties, national legislation, international duties, whatever. So there were multiple failures on the part of the states and many other things. You can see that she never received any counseling, any support, and she obviously was in need of that. She changed her physical appearance, and besides that, she was not only a young girl, but also Roma.
Classical example.
That's right.
No,
That's right.
that's one of the reasons I'm not 100% sure why she was not well taken care of.
That's right. What was the problem here? The court found the relevant violation of Article 3. So the court thought that Croatia was responsible for violating Article 3. But just one remark. Article 3 has its substantive and procedural limb. Substantive limb of Article 3 concerns the duty of the state not to prevent ill treatment and not to inflict ill treatment to a person. Procedural limb regards, the process, whether everything was fine when it comes to investigation, what happened, prosecution of the perpetrator. So in this particular case, what was problematic, and this is something Judge Derencinovic, he's a Croatian judge, opposed the majority of judges in this judgment. He said, given that not a single measure of victim protection was taken in this case, I have to disagree with the majority's decision that there is no need to give a separate ruling on the applicant's remaining complaint under Article 3 concerning the authorities' further failure to protect her from repeat victimization and intimidation. So the court only dealt with the last set of the obligations regarding the procedures against the perpetrator, not whether there was anything else the state should have done to provide protection to her. Thank God she did not, she was not exposed to something by her father, but this could have easily happened, and the state did not do anything. So have in mind this. So Article 3, substantive link, procedural link, okay? And yeah, this is the critique of the court's position. The court should have scrutinized the authorities' failure to consider whether to grant the perpetrator leave in the same part of the town where she lived, inform her of his leave, caution him to abstain from indirectly contacting him, instruct police to be responsive should she report concerns, appoint gender sensitivity trained officers as her contact, warn the perpetrator after his first threats, inform her of that and of her victim rights. So there is a series of things that the state should have done. If the state did that, there would be no violation of Article 3. But they failed to do that, and that is why violation of Article 3 happened. But again, as I said, the critique of this judgment is that court only dealt with the procedural aspect, not the substantive one. Okay, the court did not find discrimination in this case. And the last case, and we are going to end, rape as ill treatment. So these were domestic violence cases. But let's now see what is the approach of the European Court of Human Rights and its standards, and whether they are different if we're talking about rape. This is a very recent case from 2024. So X went on holiday to Greece with her mother when she was 18 years old. She was raped by a hotel bartender. The Greek authorities carried an investigation into her accusation, but decided that the charges should be dropped. She claimed that the investigation had fallen short of the required standards and that the authorities breached their duty to provide effective legal protection and to protect her as a victim of gender-based violence. You do not have too many facts here, but feel free to ask me anything. Because they said that there was not enough evidence. They said it was her word against his word, which is usually the case in rape cases.
Was she of Greek origin or?
No, she was the UK origin. She came with her mother to Greece. She met this bartender one evening, and her mother went to hotel room to sleep. She stayed with him. They had some good time, talked, etc. And then he raped her. She went back to the hotel room, told her mother what happened. Her mother called the police at 4 a.m. in the morning. The police came immediately, but they said we cannot do anything until 9 a.m. Despite that, they put them into the police car and drove for a while, and then got them back to the hotel, the mother and the daughter. And they arrested the boy, the bartender, and took him to custody. The next morning, they took her to the police station to take the statement. They asked her whether she would like to talk to him. She said no. Mother said, I would like to talk to him. And mother went to the room where he was and talked to him. While the police officers were present, chit-chatting among themselves, while the mother was talking with the perpetrator. Then they took her to the hospital to be medically examined. They never explained to her what kind of examination they would be conducting towards her. She was talking all the time with a male police officer. They did not provide for the translator. The only translator was the owner of the hotel in which they were accommodated, and his English was very, very poor. At the end, they gave her some papers to sign, and those papers were in Greek. So she had no idea what she was signing. And that's it, more or less. At one point, while she was, I don't remember whether in the hospital, she was sitting across the perpetrator in the same hallway. So more or less, these are the facts of the case. Let's do the regular procedure. The court first assesses whether the minimum level of severity was attained. So what do you think? Yeah. Which of these factors would you consider relevant to argument that the minimum level of severity was?
Women,
Foreign national. Okay. What about the failures of the state? We do not have to go, positive duty by positive duty, but just having in mind what I told you.
But wouldn't that this be the procedure of them, not the substantive one? As well as the last one.
What do you think?
I think that it was for the court to make more sense. It would be more easier to show that the Article 3 is breached due to the state's inefficiency. Let's say that.
But what about the failure to provide for protection? So there was nothing they could do to prevent that. They did not know that they would meet, talk, and then that this would happen. I mean, you cannot expect from the state to prevent everything. So, did they provide her relevant protection?
But did they assess the laws and the laws of procedure in Greece? Because if this is what happens every time, a woman gets raped, and this is the
You mean there is a systematic practice of conducting such cases in this way? Well, no, this was not the case. But generally, what were the authorities supposed to do?
Inform her about
her rights, of what they are going to do. Translator. That's right.
Not allowed to them to be so close to the what was that ride in the car? I don't know.
Yeah.
Makes sense.
Yeah. So obviously, I mean, this was considered by the court as contrary to Article 3. Again, the court did not do into distinguishing whether it's torturing human treatment, but the court did find a violation of Article 3. And for the end, something to think about. There can be, we can notice a difference in the court's approach when you have domestic violence cases and sexual violence or rape cases. It appears that the court applies different standards. For domestic violence, it insists on a higher standard. Special due diligence is required from states in domestic violence cases. And what the court also has in mind is that all victims of domestic violence are vulnerable. so far, it might change, but for the moment, the standard when it comes to other forms of violence against women is lower. So not special due diligence, but due diligence. It is important to establish that standard as well. But why the difference? Why the higher degree of standards in cases concerning domestic violence as opposed to rape and other forms of sexual violence? And what else can be noticed from the court's case law? When it comes to victims of violence against women, vulnerability is noticed by the court only if there is intersectionality. Not regarding all victims. For the moment, this is the situation, but as I said, I mean, it can change. The court was criticized for making such a distinction in its approach in these groups of cases, but we'll see whether it will react to this criticism. For the end, you could see states have an obligation to prevent torture and ill treatment whenever they exercise custody or control over individuals, but they also have to exercise due diligence even in cases where torture and ill treatment is committed by non-state actors and private persons. There is a tendency to regard violations against women and girls as ill treatment, even where they would more appropriately be identified as torture. This is something that is noticeable in the practice of international bodies. Intersectional identities can result in experiencing torture and ill treatment in distinct ways. And states have a heightened obligation to protect vulnerable and marginalized categories of women from torture and other forms of ill treatment. These would be some key messages from everything we have discussed this evening. But as you can see, even though much has been done and these standards have evolved and are constantly evolving, there still is plenty of space for further improvement. Any comments, any questions before we conclude? Today we are punctual, not like the last time. Any comments? But it's also very, very difficult.
But it's good to know.
Yeah.
This week.
What is important, I missed mentioning that, in this case, the Greek case, the court did not only go into Article 3, but also Article 8. And this is something that the court usually did earlier. Rape cases, violation of the right to private life. What is important is that the court started considering rape cases as also Article 3. So that's what I want you to take from here. It all happened gradually. Before the European Court of Human Rights, before the Committee Against Torture, before the Human Rights Committee, it did not start immediately. And all of them, they inform each other and influence each other. And other bodies as well. You got the idea how, for example, relevant in domestic violence and gender-based violence cases is the jurisprudence of Grevio, reports of Grevio for the European Court of Human Rights. They also help develop standards and make standards higher. So this interaction between different bodies is extremely important. One of these will elevate the standards. The others will follow sooner or later. And some initial limitations, like the state involvement element in torture, and inhuman degrading treatment are overcome. So it will continue to happen. But what is important is to follow the jurisprudence of this. This is very helpful. We can criticize these judgments and decisions from numerous aspects, but you can also use them in your everyday work. I mean, lawyers, NGOs, those working with victims, those judges should also be aware about these standards. Unfortunately, this is not always the case. And it is difficult to follow all these standards. They are being developed as we speak, you know. It might happen that the next year, when we have a new generation of students, I will have a new judgment from the European Court of Human Rights going even further. Who knows? You know?
Dear professor,
Yes, I cool.
I
can
have one
hear.
thing in the chat box for my topics. You can see this is okay or not later on.
I did not understand the word that you were
In the chat box. I write
in the chat
something.
box.
Yeah.
In the chat box, let me just stop sharing this.
Direct.
Direct. Localizing. That's the proposal for your topic for the exam.
Yeah.
Please send me an email. I really cannot do it through chat.
Just for one shot.
Send me an email, and I will get back to you. Okay?
Okay.
Okay. Bye.
Okay.
So next time we meet, I will work with you again next Thursday. We will have only 2 classes next Thursday, so we won't stay this long. We'll discuss gender aspects of international refugee law, and this will also be the occasion to do the non-refoulement principle. Okay. And on the 26th, you are working with Professor Kristic. You have these presentations, life, protection of life, abortion, and so on. It will be very, very interesting. So,
Mi reći najbolje pratimo ove izbore za sudije, i za tužioce kad budu nakon kad smo budu kamarali. Pa ako se slučaj da budem u četvrtak, ja pratim u Nišu, nećemo.
vi ćete u Vrhovnom savetu?
Da.
Dobro.
Tako da ću ja tamo morati da pratim za sudstvo, a za DST će biti kada će da bude. Jer to mora i se svećaju.
Dobro, što znači da sigurno nećete moći da pristupujete ili ćete se odande online uključiti?
Ne, samo to ponavljam da baš taj dan.
Dobro, nema problema. Mislim, dobit ćete opet onako i materijale, dobit ćete prezentaciju, a sve što ne bude jasno, vi ste javilo. Goodbye, Saifu, goodbye, Šarmarke.
Okay. Hvala puno, laku noć.